Okay, I'm here at the Rain Acre Conference in Calgary with Barry McGuire. Barry's been a legal professional for 35 years now, Barry?
That's right, Harold.
In Edmonton area with the Ritchie Mill Law Office?
Correct. It's all correct.
And I found out also that Barry's been a real estate investor for 39 years now and bought his first property on the order of $23,000?
$23,000 in 1972.
Oh, that's incredible. If we all knew. What was I doing at 72? Well, I wasn't buying real estate, I can tell you that, Barry. Barry, we have a couple of questions here about real estate and foreclosure, and I do get calls from time to time from people about what their issues are, about the concerns are, and Barry's been kind enough to answer some of these questions. So I'll just read off these questions. We have a couple here, and one question that we have, Barry, is what should a homeowner do once they receive a demand notice, a demand letter, or a statement of claim?
All right. The legal process is usually started when a lender issues this thing called a demand letter. A demand letter is really the lender sending a letter to the homeowner who's not paying his mortgage payments and saying, "Hi, we're the lender. You're not making your payments. If you don't catch up by such and such a date, we will start formal legal proceedings." That's called a demand letter. If the homeowner doesn't then catch up and bring all the payments into good standing, the lender starts a formal legal action by issuing this thing called a statement of claim.
Mm-hmm. Okay.
It's filed at the courthouse, it's served or given to the homeowner, and then the homeowner has 15 days from the date they get the statement of claim to make a response.
Okay. And Barry, I have another question. And how can a homeowner find out about the details of the foreclosure process so that they don't miss important court dates, payment dates, any information coming through the pipe?
Okay. You know, that, Harold, is a really good question, and often I find that that's really what homeowners want. They may not want to defend the foreclosure because really they're not making the payments, and there's no question about that, but they want to know what the steps are and where they could be involved in the process if they could be. So what a homeowner can do when they get the statement of claim is they can file something called a demand of notice. Demand of notice.
Okay.
Demand of notice is a one-page document that the homeowner prepares and files and gives to the lender and anybody else that's involved in the foreclosure action, and it then causes or forces the lender to send the homeowner notice of every step as it moves through.
I see. So they're fully updated with any activities that are occurring on their case.
Yeah. So you file the demand of notice, you serve it on the lender, and then when the lender's going off to court, they have to send you a notice that they're going to court and tell you when and where, so that if you want to go to court and say something to the judge,
yes,
you can do that. So it's called a demand of notice.
Fantastic. You
can do it on your own, or you can get a lawyer to help you with that.
Okay.
Sometimes that's all you can get a lawyer to do of any real value in these.
Okay.
Is get them to help you with the demand of notice, and then you can choose as a homeowner to either participate or not. Doesn't make you. The demand of notice doesn't make you any more liable. It doesn't cost you any money. It doesn't make you any more or less vulnerable. It just gives you notice of what's going on and gives you the chance to participate if you want or you don't want.
Okay, so there's no cost.
No cost.
And it does allow you to be in the loop and make sure you have all the information and make those important dates that you need to be aware
Exactly.
of.
That's exactly it.
Okay, perfect. Thank you. Okay. Hey Barry, what about a condo board? We have questions about condo boards and their interaction with condo fees and special assessments. Can they initiate a foreclosure on a homeowner?
Yes, they can. If there's any situation where a condo board is owed money, they can start a legal action that is so similar to a foreclosure that you may as well call it a foreclosure.
Is it?
So
okay.
they can do that. Often, if you owe money to the condo board, to the condo corporation, they file what's called a caveat against your property.
Okay.
The caveat says, "Hi, we're the condo corporation, and Bill Jones owes us $500 for his condo fees, and he hasn't paid." So that's registered against your title, and if you then continue not to pay, then the condo board, condo corporation, can start a legal action and essentially it's a foreclosure.
Okay.
And they can really foreclose you for failing to pay $500. So it's very serious. You can't ignore those notices from the condo corporation.
Very good information. Okay. Fantastic. Barry, what about the homeowner's rights after the redemption period expires?
You know, Harold, that's something that's not really very well known. If you're a homeowner and you have equity in your home, the courts are very interested in protecting homeowners. They do not want to kick you out of your house. So they're very interested in protecting. And if you have any amount of equity at all, and a lender starts a foreclosure, you will always get a 6-month redemption period. It means you have 6 months to try and find the money to bring the mortgage back into good standing.
I see.
So at the end of the 6-month redemption period, if you haven't been able to bring it back into good standing, the lender has the right to go back to court and say, okay, court, they haven't paid, we want to foreclose on the property. The court might say, okay, great, we're going to let you now sell the property, and you list it for sale, and the court hires a realtor, and they look for offers, and they find buyers, and they go back and forth, and then they find somebody to sell it to. And this might have taken another month or two after the expiration of the 6-month redemption period. They find a new buyer, they sign a contract, and homeowner magically wins the lottery. His rich uncle dies and gives him some money. Doesn't matter. Whatever the reason is, he now has money in his hands to pay off his mortgage. He can bring up all his arrears. As long as the property hasn't actually transferred to some new buyer, you can rush in there at the last minute, even though there might be a signed contract with somebody else.
Signed offer.
Signed contract, and say, Judge, I've got the money, and they will, I'm not saying 100%, but the homeowner has a very good chance of still being able to pay off his house and keep the property.
Barry, I wanted to really thank you for taking the time today to help us with these questions. I do get these questions on a regular basis, and I know people will feel a lot more comfortable seeing you being a lawyer for 35 years in Alberta, knowing Alberta law really well, and being able to educate our audience with the right answers for these questions.
Thank you very much,
Appreciate your time.
All right. We'll do it again. Thank you.